Hello friends, you're watching Real Talk. Let's talk about issues that have been dominating the headlines. And one such issue is the rioting that we were witness to in Sambhal. It was very disquieting. In fact, some commentators speaking about these riots broke down live on televisions. Now there is a bid, viewers, to move court to stop surveys on mosques. We're asking whether these moves to stop surveys on mosques will end up disenfranchising the Hindu community. I know it sounds a bit contradictory, but this entire move is being led by the Congress party. In particular, Rahul Gandhi and Priyanka Gandhi Vadra. They found this as a new cause, a cause that will see them drive by car for about 3.5 hours to Sambhal, Uttar Pradesh. That attempt, as you know, was halted by the Yogi government. Their visit to this town could not take place. But it was in the backdrop of a court-mandated survey on a mosque to determine whether it was built atop a temple. This survey was almost derailed at gunpoint, and you saw all those pictures. Thousands of Muslims, thought to be locals, pelted stones, allegedly fired country-made guns, and threatened ASI's team of surveyors with dire consequences. Now, friends, this violent revolt against the writ of the law has brought an ecosystem of Modi government critics and their patrons in opposition parties like the Congress, as I told you, to the point of a meltdown. Literally, a senior Supreme Court lawyer wept inconsolably on camera, bemoaning how the Supreme Court had let down Muslims by opening the doors for Hindus to dig up their places of worship in a bid to usurp them, to swallow them up. These self-styled activists for minority rights are convinced that the lower judiciary would not have ordered these surveys that undermined the sanctity of a law called the Places of Worship Act 1991. This law, viewers, had been passed by the Congress Narasimha Rao government 4 decades back. These activists claim that had former Chief Justice of India Bobde and Chandrachud not overruled this law or made allowances in this law, it would not have paved the way for the rioting in Sambhal. The allegation is that the ex-Chief Justices of India and their orders sympathizing with Hindus has given a sanction to, quote, dangerous legal adventurism, unquote, allowing Hindus to look for shivlings under every mosque. To stop the alleged, quote, persecution of Muslims, unquote, and the legal assault on their place of worship, the Congress party has moved the Supreme Court, seeking a stay on the survey of any masjid. The Congress says that the courts must uphold the Places of Worship Act 1991 that debars any such changes, any such surveys, any such investigations, any such claims. The petitioners have made the following points to oppose the surveys. First, the Places of Worship Act 1991, they say, imposes a bar by Section 3 on the conversion of a place of worship on any religious denomination after August 15, 1947. In other words, it freezes the religious identity of that place of worship in perpetuity and discourages any legal moves to file fresh suits or cases to alter the status. Second, the Congress says mosque surveys are against the spirit of the Supreme Court order in the Ayodhya matter that reposed absolute faith in the power of the Places of Worship Act 1991. The Supreme Court in its Ayodhya judgment dissuaded Hindu groups against trying to reclaim mosques built over their place of worship. The Supreme Court noted, and I quote, "The state has, by enacting the law, enforced a constitutional commitment and operationalized its constitutional obligation to uphold the equality of all religion and secularism, which is a part of the basic features of the Constitution," unquote. Apart from this reason, apart from citing the Ayodhya judgment, the Congress says that the Supreme Court had in 2019 in another judgment set aside the findings of Justice Sharma of the Allahabad High Court, who had ruled that the Places of Worship Act 1991 does not debar Hindus from filing cases to determine the character or identity of a place of worship that existed before the Places of Worship Act 1991 came into force. In other words, if it is an ASI protected monument that was built before 1947, a survey could be conducted on determining its character. Now, these questions arise. The first of these big questions is, are these reasons to seek a bar on surveys of mosques robust enough to convince the Supreme Court to order a ban on surveys of mosques that Hindus believe were constructed by destroying pre-existing Hindu places of worship? Not quite. That's the answer for three reasons. First, the Congress citing the Ayodhya judgment that links the Place of Worship Act 1991 to secularism does not stand the test of logic. What's secular, after all, about denying Hindus, a community that has suffered the most excruciating religious oppression and genocide at the hands of anti-pluralistic Islamic colonizers, a shot at justice? Isn't it as if Hindus are reclaiming their cultural totems by force? No, viewers, they're not. Can any citizen or citizen group be debarred from seeking legal recourse? Won't that amount to disenfranchising the citizen or citizen group, in this case, law-abiding Hindus? And if a law does purport to deny this basic right, is it even in line with the basic features of the Constitution? After all, how can any constitution debar anyone from moving court to defend their rights or demand them? Top liar Sai Deepak points out that Hindus cannot be forced to sacrifice the right to peaceful reclamation of their place of worship at the altar of secularism. Deepak cites the United Nations Declaration on the Rights of Indigenous People, or the UNDRIP 2007, specifically Article 11, Clause 2, which expressly requires countries to provide effective mechanisms for restitution to indigenous communities of, quote, cultural, intellectual, religious, and spiritual property taken without their free, prior, and informed consent or in violation of their laws, traditions, and customs, unquote. Simply put, what Deepak is saying is that there is a United Nations Convention which allows people of a particular country, especially indigenous people, to reclaim what was theirs but was forcefully taken away from them. If this is the case, Deepak wonders, then how can Bharat, as a society that has suffered two waves of monochromatic colonization, justified the continued existence of the POW Act 1991, which stops indigenous communities from reclaiming what is theirs? Deepak notes that, quote, as a country that voted in favor of UNDRIP, or this UN convention, surely Bharat cannot ask for the return, for example, of the Kohinoor diamond from Britain on the one hand, and on the other hand, defend a law that bars Hindus from seeking internal reparations, citing secularism. Wouldn't that amount to speaking from both sides of the mouth on the same question of principle, unquote, he asks. And that's a fair question, viewers. Now let's examine the issue from the perspective of the second reason proposed by the Congress to oppose surveys on mosques. While the Ayodhya judgment of the Supreme Court in 2019 did talk about the need to uphold the sanctity of the POW Act 1991, it has no precedential value. This is because it is well settled in law that a court cannot pass judgment on issues that it has not been specifically called upon to opine on. Thus, the Ayodhya judgment does not stand in the way of any Hindu group moving court to challenge or legally scrap the law or amend it. Lastly, let's talk about the third reason put forth by the Congress party, which is that the Supreme Court had already overruled the Allahabad High Court order passed by Justice Sharma ordering the surveys of mosques. Well, it is true that the Supreme Court had passed this order, but that order is said to be infirm in law. First, it is said to have wrongly interpreted the High Court order. Justice Sharma was only quoting a previous Supreme Court order passed in 1993 that allowed for Christian petitioners to verify the character of a disputed church. Sharma, as such, didn't opine on the merits of the Supreme Court order. And finally, in May 2022, ex-Chief Justice of India D.Y. Chandrachud had said that although the Place of Worship Act prevented the nature of a religious place from being changed, merely ascertaining the religious character of a place would not violate the law. After all, think about it. Can a mosque be a mandir also? And can a mandir also be a mosque? No, it can only be one of the two. And therefore, if the character, the identity is in dispute, it would have to be resolved. Otherwise, it would lead to an untenable situation where two communities would constantly be clashing. For these reasons, moves being made by the Congress seeking a bar on surveys by the Hindu community will not withstand the test of scrutiny in court. This is what a large number of lawyers who have looked at the issue in depth believe. But in the interim, till the Supreme Court decides, or a court that the Supreme Court assigns to decide upon the issue, the Congress plea will only serve to disenfranchise Hindus. And that is problematic in a secular country. Thank you for watching.